Okay. Give us your perspective on this Supreme Court matter and Bode George, because I think it was on Sunday where Mr. Falana, SAN, released this comment saying that the Supreme Court was wrong in quashing the conviction of Chief Bode George.
You see, with the greatest respect to my brother Falana and also Professor Sagey, I think Professor Sagey anchored, the same opinion as Falana. But I believe that they have done it in the wrong way.
Why?
You see, under the Constitution, the Supreme Court, as the apex court in Nigeria, is the final court of arbitration in any matter. The only appeal you can take is to take it to God. But within the system, the Constitution says, look, when the Supreme Court decides on a matter, you can still go back to that court and ask for that matter to be reviewed.
So the Supreme Court can reverse itself?
And now let me explain it to you. A review is not an appeal. The system says, or the Constitution says, that if that error you have discovered in the judgment is going to lead to a miscarriage of justice, then you can sit us down, we will look at it. Let me give you a clear example. I am not saying this for any ego. Last year, I challenged a judgment of the Supreme Court in a case in which my client was involved with the central bank. I wrote a petition.
So the Supreme Court can be challenged?
Oh yes, I did it last year, and that's what I'm trying to say. I now challenged that judgment and I asked it to be reviewed. At first, and you have to give credit to the present Chief Justice of Nigeria, when I wrote to her, she replied that under Section 294 subsection 5, we cannot review it. Despite and in spite of her letter to me, I decided to file the application for a review. Seeing what I have stated down against that judgment, she quickly set up a panel. And that's why I say you have to give her that credit. She set up a 5-man panel, and I had to address the Supreme Court again, even though I lost. But they gave me that opportunity. What I'm now saying is that Falana and Sagey, they are aware of these provisions. Because when you start politicizing judgments of the Supreme Court, the way and manner is being done, it is not fair, because these people cannot reply. When you have within the system an avenue to ask them, look, why should you declare Section 104 and Section 203 of the laws of criminal laws of Lagos State illegal without listening to the Attorney General doing this? Why not go back and bring an application for that judgment to be reviewed so that your grounds about that particular annulment of those two sections can be heard? Because the only time the Supreme Court can reverse itself is when a similar case comes and then they review their position in the... Let me give you a clear example. We have what we call conflict of judgments of the Supreme Court. Supreme Court on a point of law might decide, and tomorrow they decide it another way. There is a particular case I took up 2 years ago in the Supreme Court also, where justices of the Court of Appeal, a particular, panel, refused to follow the latest judgment of the Supreme Court and decided to follow an earlier judgment of the Supreme Court, which was in conflict with the latest judgment. I now went to the Supreme Court and I decided to say, look, what does it matter if you don't want to review a judgment? The point now is this. The Supreme Court now says that if we have an earlier judgment which now contradicts our present judgment, it should not be regarded as a conflict if our attention is drawn to that judgment. So that area has been settled. So I will have urged Falana and Sagey, instead of politicizing a political case, because Bode George's case is political, no matter what angle you want to look at it, they are now politicizing it it's not doing, good for the credibility of the Supreme Court. I'm not defending the judges of the Supreme Court here, but what I'm saying is that they have no right of reply to all this criticism, and nobody is going to help them to say, oh, this is why we did this. So, to help the judicial system in this country, Falana and Sagey should have gone back to the Supreme Court, bring an application for it to review that aspect of its judgment, and they will gladly do it.
So first they had that option, and even if they had taken that option and it still didn't go the way they wanted, could they have made, or could they still be able to make a comment or two saying, look, well...
You can make comments about judgments, don't get me wrong. You can write articles criticizing judgments of the Supreme Court. I have done it. 10 years ago, there was a judgment by the Court of Appeal in Lagos convicting certain Air Force officers under the court-martial system. And, I criticized, the Supreme Court reversed that judgment, and I criticized the judgment of the Supreme Court in the newspaper. That is constructive criticism. But when you now make comments, to say, oh, the Supreme Court was wrong to have done this, without following it up legally, then you are not playing to the rules.
So what you want them to do is also not just make comments, but follow it up legally as well. Is that what you're asking them to do?
What I'm saying is this. The judges of the Supreme Court have no opportunity to reply. These statements have been made on a political case. Forget that it's a criminal case. Bode George's case is political. It has political following. It's just like Al-Mustafa's case. No matter what you say, it's a political case. Now, what I'm saying is that Falana and Sagey could have taken this matter up in a legal manner by asking the Supreme Court to review that judgment, especially that area of Section 104 and 204.
What if laymen were the ones to criticize? Because some people have, come up with the stance saying that it's not right to criticize a Supreme Court judgment. The Supreme Court is the Supreme Court. But others have argued that the Supreme Court is not infallible, that they can make mistakes, and it's so unfortunate that that's where it stops after them. It's God.
You see, in all civilized countries,
yes,
that follow the same system of judicial system we have, in America, in India, in Australia, they allow reviews of their apex court judgment. And I mentioned this in the brief I wrote when challenging a judgment, that it is not an uncommon thing. In Great Britain today, there are 10-15 cases of judicial review of apex court judgment. In Australia, so it's not new. It's only in Nigeria we prefer to go to the newspaper and challenge things when the other party cannot reply. My own contention is this: you are bringing judges of the Supreme Court into the arena of public opinion when they cannot reply. Whereas you have an alternative. You can still get the political aspect of that by even going to court to ask them, oh, I am not happy with your pronouncement on Section 104 and 203. I want you to review it. They could have still got the same political whatever it is through the legal manner.
The question would also be what you make of their comments. I mean, aside the fact that you quarrel with them that they didn't ask for a review or not taking it through the legal channel, do you have quarrel with the content of their criticism?
You see, the law, nobody is the custodian of law. The way they see a legal point may be different from the way I see a legal point. I am not going to challenge a judgment if I have not read it. I have not read Bode George's. What I'm just saying is that that aspect of that judgment, which they now start to criticize, they should have done it in a better way than the way they are doing it.